Welcome and thank you for joining us for part 2 of our 4-part on-demand learning series focused on estate planning. My name is Becky Wiest and I am an instructor and research specialist at Howard County Library System. We are excited to partner with King Hall LLC, a law firm located in Ellicott City, Maryland, to provide you with this educational resource. Today, two of King Hall's associate attorneys, Kelly Renaud and Michael Dubé, will discuss the trust-based estate plan.
Thank you, Becky. Most people think of an estate plan as simply planning for the distribution of your assets after you have passed through the creation of a will. A well-drafted plan consists of more than a will and should also include an advance medical directive and a power of attorney. In some situations, you should also have a trust. The goal is to have a plan that is usable, flexible, and meets your needs for a long time to come. Together, this set of documents allows you to safeguard your goals, protect your values, and avoid or at least delay guardianship.
In this series, Kelly and I will discuss many of the estate planning options. We discussed the will-based estate plan in our previous module. Today, we will be discussing the trust-based estate plan, which shares some characteristics of the will-based plan, but diverges significantly in other areas, especially since the Register of Wills and Orphans Court, unlike in the will-based plan, play little role in the process.
Recall that in the will-based estate plan, the main document is the will, along with any ancillary documents such as the advance medical directive and power of attorney. In the trust-based estate plan, a trust is added, which carries out most of one's estate planning objectives instead of the will. The ancillary documents remain to round out this estate planning option. Thus, the role of the will is reduced to what is often referred to as a pour-over will. It functions as a safety net, catching any assets not already in your trust and pours them over to the trust at your death. The assets contained in the trust will not pass through probate. By having most or all assets pass outside probate, the probate process is streamlined and thus much easier for your personal representative. We will more fully explain this trust and what happens at death. Michael, what is this trust all about?
Sure. So trusts are a very flexible living document, and there are many types, which we will discuss at length in our next installment. Please keep in mind when we say that a trust is a living document, we mean that it is active upon execution, whereas a will is active when the testator passes away. Know that the trust in a trust-based plan is different from the testamentary trust that we discussed in our first installment of this series, because the trust is created while you are alive rather than upon your death. That being said, it is still a legal relationship wherein one person, the settlor, or more commonly the grantor, gives legal ownership of specific property to a second person, called the trustee, to use for the benefit of a third person, called the beneficiary. The trust in the trust-based estate plan is called a revocable living trust, which is exactly as it sounds, a trust created while you're living and that can be changed or revoked. Importantly, creating the trust is not enough. The trust must be funded. Funding effectively means that assets need to be retitled into the name of the trust. Property, for example, has to be redeeded into the name of the trust and have the trust as the owner for the property to be considered in trust. An unfunded trust has no legal effect. A common error among those less familiar with trust and estate work is to create a trust, but not to fund it, which essentially renders the trust moot. There are a number of roles at play during the creation of trust. We've alluded to them already, but it bears repeating them. The grantor, this is the person or persons who create the trust. Settlers is a common synonym. Trustees, a person, either an individual, a corporation, or more than one of either, who administers the trust. A trustee is considered a fiduciary and owes the highest duty under the law to protect trust assets from unreasonable loss for the trust beneficiaries. A beneficiary is anyone who receives a benefit from any asset that the trust owns. And please note that when it comes to a revocable living trust, the testator is grantor, trustee, and beneficiary. So they occupy all three roles. And a quick note on income and principal. During the life of the trust, income earned is distributed toward the grantor, and only after death does property transfer to the beneficiaries of the trust. Please keep in mind that this income is taxed as such. In order to create a trust, the grantor writes a document called a declaration of trust. In the declaration, the grantor transfers legal ownership of the property to be placed in trust to the trustee and names the beneficiary. The grantor must be legally competent to make the trust. Remember, competency is a specific definition that we have discussed in our first module and will discuss in even greater detail during our final presentation on guardianship. Please also note that the trust does not exist until a trustee accepts receipt of the property. A trustee may be a person, institution, or other organization. The declaration can include a list of backup trustees in the event a trustee cannot continue in their role. And the trust can be set up with the grantor as the first trustee. Trusts created under the Maryland Discretionary Trust Act assume that the grantor, called the declarant, will serve as the trustee. The property to be held in trust must be specifically described in the declaration of trust. For example, as discussed, real estate has its own rules for transfer. Trusts created under the Maryland Discretionary Trust Act have to say that property is to be held in trust under the Act. Trusts under the Maryland Discretionary Trust Act with no designation will be assumed to be revocable. Another important aside is that trusts are not just for people with extreme amounts of wealth or property. Trusts have become ubiquitous and should be seriously considered no matter the size of one's estate. The law provides this unique tool to everyone. So Kelly, can you explain what happens when the grantor dies?
Certainly. So what happens when the last or only grantor passes? Well, your will is still submitted to probate and your estate is still administered by a personal representative. The probate process, however, is much less complicated because your trust is doing the heavy lifting and it does not pass through probate. Remember, in our last episode, we discussed the probate process at length. As for the trust, the successor trustee named in the declaration of trust takes over. The trust becomes irrevocable and is administered per the instructions in your trust, hence the administrative trust. How the trust is administered has already been designated by you as the original grantor. Some common things that happen, or at least what we see, is that there can be outright distributions to your beneficiaries, or the assets can be left in further trust. For example, in legacy trusts, where you leave assets for your beneficiaries. Other types of trusts can be included, such as charitable trusts. We actually have, in the next episode, more information about the different types of trusts available. Now, if you happen to be married, often the married couple will execute a joint revocable living trust, wherein they are both named as co-grantors, co-trustees, and beneficiaries. So there's an interim step when the first spouse dies. The assets in that joint revocable trust usually flow into either a bypass trust or a marital trust. The bypass trust will contain assets in an amount up to, but no more than the allowable estate tax exemption amount. In this way, no estate tax is paid on these assets, and that tax effectively bypasses the surviving spouse. This particular trust is irrevocable. The surviving spouse does not hold the assets directly. Although they can benefit from this trust, they may have a right to its income, a right to its principal under an ascertainable standard. They also have a limited power of appointment, which means that while they can appoint beneficiaries of this bypass trust, it is only from a limited pool of options. Because the survivor does not exercise full control over the assets in the bypass trust, they are excluded from the survivor's estate at their death. In other words, any remaining assets go to their beneficiaries free of estate tax. Now, if there are assets in that original joint revocable trust that are greater than the amount that is allowed as an estate tax exemption, then those assets over and above that amount flow into the marital trust. This is revocable and belongs to the surviving spouse. The surviving spouse is the trustee and has the right to all income and has the right to all principal. The survivor has a general power of appointment, and these assets may be subject to estate tax at the time of death. While it may take more to establish a trust-based plan that is more involved to establish and fund, there are many benefits to a trust. Some of these were alluded to in our first episode, such as use as a credit shelter, use in distributing assets to a minor or when there is an incapacitated person. And there are tax benefits. All this work upfront will pay off on the back end when your personal representative and successor trustees step in to administer your estate and trust at your death. Their jobs will be easier because you have already done much of the work for them. And in so doing, you have indeed preserved your goals and protected your values. Please check out our next video on trusts for more detailed information.
So to wrap this up, we'd recommend that whatever planning documents you have, safeguard the originals and share your intentions with those that need to know. Unlike wills, the Register of Wills does not act as a repository to store trusts. Trust should be held in a secure place, and the parties to the trust should have knowledge of its location and your intentions. Otherwise, you are inviting discord and potentially trust interpretation litigation in the circuit court.
All right, thanks so much, Kelly and Michael. We have a few questions. First up, are any other people involved in a trust besides the grantor, trustee, and beneficiary?
So as with all legal questions, and perhaps unfortunately, the answer is that it depends. There can always be other individuals or entities involved when a trust is in play. Those people and entities could be a trust protector, who is usually there to appoint a successor trustee when there is no named successor trustee left. A trust protector would also help avoid court involvement, which would be, expensive. There could also be a trust company who would stand in for an individual. There could also be third parties such as a financial or an investment advisor or a doctor or other mental health professional if there's an issue of capacity at play. And ultimately, the court could be involved, though one would hope to avoid its involvement. The circuit court would be responsible for adjudicating any trust-related issues.
Right, our next question, how do I fund my trust?
Well, Michael already alluded to one example of when somebody would like to put their real property in trust. Anything with a title, such as real property, a house, land, or a banking account, needs to be retitled or in the case of a house, redeeded in the name of the trust. So that deed would need to be redrafted and re-recorded with land records before the house is in trust. The bank account would need to be opened in the name of the trust, and then those financial assets would have to be transferred into that bank account for the money or those assets to be considered in trust. A trust can also be listed as a beneficiary on accounts such as retirement accounts, life insurance policies. And another example is personal property. Say you want to hold your jewelry in trust. This can be done through an assignment of personal property, where a document is included in your entire trust document where you would list all the personal property that you want to be or that you assign to the trust. So depending on what it is you want to have in your trust, there are different ways that different actions you need to take to make that happen.
And our last question, how long does a trust last?
So a trust can last a very long time. In fact, it can last across generations. But generally, trusts end as soon as the first of four things happen. The first being that the beneficiary passes away. The second would be that the trust terminates based off of language in the trust itself. For example, if the trust has served its purpose already, then it would terminate. Or if there's been a judicial cause to terminate the trust, for example, an extreme breach of fiduciary duty by the trustee. The trustee is also allowed to terminate a trust under the Maryland Trust Act if there's a low value of assets in the trust, which effectively renders the trust, void at that point.
We hope that you found this presentation helpful. We actually have 3 others in this series: the will-based estate plan, the different types of trusts, and how to avoid or at least delay guardianship. Of course, you can always contact us at our office for additional questions and assistance.